in life in a number of different ways. And criminal records create barriers to public benefits, higher education, and most notably employment and housing. I would say employment and housing are the two areas that are most greatly impacted when it comes to criminal records. And we know that 40% of offenders will return to state prison within 3 years of their release. So it's important that we address the barriers that are created by criminal records because we know that employment and housing are the two biggest factors to prevent and reduce recidivism. Natalie, if you could, thank you. So when we're talking about sealing a criminal record, it's often referred to as an expungement. So what is the difference between an expungement and sealing a conviction record? An expungement, the records are totally erased. They are permanently irretrievable. And unfortunately in Ohio, it's really only juvenile records that are able to be expunged. What we're really talking about for adult records is sealing the record. And what that means is that the record is maintained, but it's maintained in a location or in a file, in a system that is not accessible to the public at large and is only accessible to certain individuals or organizations identified in the statute. So the analogy that we like to use for this is, when you're sealing the records, the records are removed from the file cabinet where everyone has access to the records, and they are moved to a file cabinet where only some people have access to those records. And that's really what we're talking about when we're talking about criminal records in Ohio. The people or the organizations that still have access to sealed records when they're in the new file cabinet are prosecutor, judges, police, other law enforcement agencies. But even their access is limited to certain circumstances. Certain employers are able to see even sealed records. And those employers are typically in fields where there's a vulnerable population involved. So we're talking about children, elderly, healthcare industry, nurses, home healthcare workers, places like that. And then, certain licensing boards also get access to sealed records. So for example, the accounting board, nursing and medical boards, the casino control commission. Okay, so the statutes that govern the sealing of criminal records for convictions, it's revised code 2953.31 through 0.36, and for non-convictions, it's 2953.51 to 52. And I will go over those a little bit. We're going to start with convictions. Thank you. You can, in order to seal the conviction record, you have to meet certain requirements. The first requirement is you must meet the definition of an eligible offender. The second requirement is waiting the requisite waiting period. And then lastly, an individual does have to affirmatively petition or file something with the court to seal the criminal record. So first, I'm going to talk about eligible offender. There are two pathways now to meeting the definition of eligible offender. The statute that governs record sealing has changed significantly over the past 15 years since I've been doing this work, and has subsequently become more complicated. But it's good because it's been an expansion. When I started this, very few people were able to get their records sealed, and now our statutes allow for many more people to be able to seal their conviction record. But it is a little confusing. So the first pathway the individual who is seeking to seal their records in order, if they want to be considered an eligible offender under this first definition, they cannot have been convicted of any first, second, or third degree felonies. And whatever their convictions are, they cannot be an offense of violence, and they cannot be, sex offenses. So that's pathway number one. If someone doesn't meet the definition under the first pathway, there is a second pathway. And that pathway, the applicant can only have been convicted of, and it's a strange combination, but 1 felony and up to 4 misdemeanors, up to 4 misdemeanors alone, or exactly 2 felonies and 2 misdemeanors. So we'll review. So, and then there are certain convictions that cannot be sealed regardless of which pathway you're in. Thanks, Natalie, for keeping up. So first or second degree felonies cannot be sealed. Offenses with mandatory prison terms cannot be sealed. Traffic offenses, felonies and first degree misdemeanors where the victim was under the age of, or was 16 years of age or younger, or under 16 years of age is really what the statute says. And then there is a list of certain prohibited offenses that are detailed and listed out in Revised Code 2953.36. But again, largely what is listed there are offenses of violence and sex offenses. So individuals with those types of convictions are not able to seal those records. I just want to real quick before we move on, so give an example of, so in our work, we see a lot of individuals with, they may have like 10 misdemeanors. So, that person, so long as they're not, those misdemeanors are not, any of them are not an offense of violence or a sex offense, would, be able to seek the record sealing under pathway number 1 definition of eligible offender. The pathway 2 opens up for individuals who might have, a third degree felony and, a couple of different misdemeanors. In that case, there's a little, there isn't the same bar for the offense of violence or the sex offense. Then you sort of have to look at that list of prohibited offenses that are in the statute. You can see though how this can be complicated for an individual to figure out on their own, or anyone other than an attorney. Natalie, you could go to the next slide. Thank you. So in addition to meeting that definition of eligible offender, the individual has to wait a certain amount of time. If the offense that they are seeking to seal is a misdemeanor, they must wait 1 year after discharge of the misdemeanor. If they are seeking to seal a 4th or 5th degree felony, they have to wait 1 year after the felony has been discharged. And then if it's a 3rd degree felony, they have to wait 3 years. If somebody has sort of a combination of felonies and misdemeanors, obviously the longer waiting period is going to apply. And when I say discharge, what I mean is that the individual has satisfied all of the sanctions that were part of their sentencing. So that would include restitution and fines, any fines that were assessed. I will say court costs should not be a bar to seeking the sealing of a conviction record. So that is, a court may deny a petition based on unpaid restitution and fines, but it is not allowed to deny a petition because the petitioner has not paid the court costs associated with the underlying criminal conviction, or court costs on some other case they might have. If the the law is very clear that a court cannot deny a record sealing petition simply because the person owes court costs. So other sort of requirements, again, that all sanctions must be completed. They can't have any pending criminal charges. The applicant has to show to the court that they've been rehabilitated. They must show that their interest in sealing the record is greater than the government's need to maintain that record. And then lastly, when they petition, the process for filing for the criminal record sealing, the individual must petition each court and request that that conviction be sealed from each court where the criminal case happened. So that was convictions in a nutshell. We also have folks who have non-convictions, and these are cases where an individual was charged with a crime, but there was some court proceeding, but they were not actually convicted. And so this non-convictions, again, are governed by Revised Code 2953.52. It's a much simpler process. There is no eligible offender requirement, but it is best if the person who is seeking the sealing of the non-conviction not have any pending cases. And then there are some waiting periods. Well, I should say there's waiting periods for charges that went to the grand jury, but if the person's non-conviction was a dismissal, so they were charged, they went to court, but for whatever reason, the court dismissed it, they do not have to wait any time to ask that that record be sealed. A nollie, what that is a case where the prosecutor has decided to not pursue charges. So again, the person was charged, there was a court proceeding, but the prosecutor said, we're not going to proceed with this, and the case is dropped, essentially. And then lastly, a not guilty. So again, that's someone who's charged, there's a court proceeding, and they were found not guilty in the court by the judge or jury. A grand jury no bill is when an individual is charged, or it goes to the grand jury for indictment, but the grand jury comes back and decides not to indict. There is a two-year waiting period to request the sealing of that whatever that criminal record is, and the reasoning behind that is prosecutors have a certain amount of time before they are allowed to, or within a time frame in which they're allowed to bring, charges to a grand jury again. So that's non-convictions. Before I talk a little bit about the effect of sealing a criminal record, I just wanted to touch on the process, and I mentioned this a little bit, but an individual who is seeking to seal their conviction record, again, must file a request, a motion, an application, however you want to refer to it, but something in writing. They must file affirmatively with the clerk of courts in the court where the criminal conviction happened. So if someone's convictions are from Cleveland Municipal Court, but they also have something in Shaker or Lyndhurst or Lakewood, they must file the request to seal in each of those courts where those convictions are sort of held or housed, I guess you could say. The statute is very clear that the courts are supposed to only charge $50 per application per court. So if someone has multiple convictions within one court, the court is really only supposed to charge them $50, even though there's multiple convictions. There is inconsistency across the board about the fees that the courts will charge. I would encourage anyone that is working with folks and running into problems regarding filing fees for these to let us know if you hear on the ground that there's a lot of problem, because there is a lot of inconsistency among particularly municipal courts and how much they charge for filing these petitions. But once it's filed, it is filed under the same case number as the criminal case. From there, a probation report is ordered, which is really a background check. So that provides information to the court about, again, any outstanding warrants, any outstanding criminal cases, you name it. It gives a snapshot of, sort of what that individual's history is in that moment. And then the statute is clear that the court is supposed to schedule a hearing. Again, there's inconsistency among courts in our region. Some courts routinely schedule a hearing, other courts do not. But they are supposed to schedule a hearing where the individual has an opportunity to go before that judge and provide information and an explanation as to why they believe they're eligible for the record sealing and they've been rehabilitated and why the court should seal the record. We hold, we obviously assist with the record sealing process. An individual who comes to legal aid for assistance with criminal record sealing, they first are obviously screened for eligibility to make sure that they're eligible for our services. But once they're approved, we schedule them for our record sealing clinic. We do an eligibility assessment to determine and confirm that we believe they are eligible, that they will meet the definition of eligible offender. And then we, again, schedule them for a clinic. They meet with volunteer attorneys, and we do provide them with the pleadings that they need to then take to the clerk of courts and file with the court and proceed through the court process on their own. For most individuals, that is a smooth process, but we do advise folks to come back to us if they have any problems. Once the court grants the record sealing, again, our statutes are clear. Revised Code 2953.33 has this language that the individual, once they have that record sealed, is restored to the rights and privileges that they had before with that conviction. And then they are not, when faced with an application, they are able to answer on the job application that they don't have a conviction. The language in the statute, you can see here that I've included, says, in an application for employment license or other right or privilege, they cannot be questioned about any conviction unless it bears a direct and substantial relationship to the position for which the person is being considered. But we do advise most individuals that once the conviction is sealed, they are able to report, and answer honestly on a job application that they don't have those convictions. So that was a lot of information in a very short period of time, and I see there's lots of questions in the chat. Before we get to those, I do want to talk about another tool that we have in Ohio to help deal with the barriers of criminal records. And it is what is called a Certificate of Qualification for Employment, or we often refer to them as CQEs. A CQE is governed by Revised Code 2953.25. If you're tracking the statutes, you'll see that these statutes are all within the same chapter and lumped together. It's actually the post-conviction relief statute. But the CQE was designed in recognition that sometimes there are what we would refer to as collateral sanctions of a conviction. And so those are all the sort of barriers and effects that a conviction may have, but are not actually part of the sanction or the sentencing that the individual received from the court. And as I discussed at the beginning, we know very clearly that criminal records interfere and create barriers in a number of different ways. The CQE was designed specifically to remove automatic and statutory prohibitions against individuals seeking certain employment and professional licensing. So that would be, for example, someone wants to go into some particular career field. Let me use STNA. That's a state tested nursing assistant. Those positions are in high demand. They tend to pay, more than minimum wage. But because it is in the healthcare industry, individuals who have criminal records, even if those records are sealed, the employer may be able to see them, or they may run into licensing or certification issues because of those criminal records. So in that circumstance, we would suggest to that individual, not only should they attempt to seal their criminal record, but they should seek a CQE. With a CQE in hand, they're able to say to employers as well as licensing bodies, I have this certificate of qualification employment. The statute may say that I'm not allowed to be licensed or have, certain employment because of this conviction, but I have the CQE. With the CQE, you are now allowed to look at me as an individual and make an individual assessment about whether or not I should have this employment or licensing. The key for employers, and I think this is why, although the CQE was initially designed to remove licensing barriers, it's often used as for general employment as well, is because there's a provision in the statute that protects employers from negligent hiring in the event that this individual who has a criminal record commits some crime related to what they've been convicted of while they're employed. In that circumstance, the employer is able to say, I hired this person, yes, knowing they had a criminal record, but they have the CQE, and because they have the CQE, you can't sue me for hiring them and employing them, even though I knew they had a criminal conviction. I am not aware of any litigation or employer ever relying on that provision. And there's certainly plenty of research to show that individuals, with sealed records or in employment, that there isn't really a whole lot of litigation with negligent hiring in this context. But that is protection that employers like to have. It makes them feel better about hiring people with criminal records. Okay. So I have like 5 minutes. I want to go through this and make sure we have ample time for questions. So anyone who is subject to any collateral sanction as a result of a conviction is able to apply for a CQE. And again, sealed records will do the trick for a lot of folks. But again, anyone who is seeking employment or licensing in an area where those employers are still going to be able to see the sealed records, we typically recommend they get a CQE as well. To understand what collateral sanction they might be subject to per statutes, per our statutory law in Ohio, there is this really great database called the Civil Impact of Criminal Convictions database, and I provide the link there. You can go to that website and type in an individual's conviction, either by, just simple language, theft, or you can actually use the statute that they were convicted under if you have that number, and it'll pop up a list of every instance in the Ohio Revised Code where there is some collateral sanction that person is going to be subject to because of that criminal conviction. So that's a really great resource, particularly for individuals who are considering, particular career fields. It'll even show you not only employment related sanctions, but housing related sanctions and things like that. So it's really a great resource. An example, again, where there's automatic bars for licensing, it's like accounting, barbers and cosmetology, junkyard operations, funeral directors, investigation, security, you name it. There are all kinds of automatic prohibitions for various types of convictions for all kinds of different occupations that require licensing and certification. Most courts will accept that a criminal record creates a collateral sanction to employment. So those individuals who are seeking the CQE for general employment, it's not necessarily related to occupational licensing or certification. In my experience, most courts understand that a criminal record creates a significant barrier to even just, a very basic entry-level minimum wage type position. Like the sealing of criminal convictions, there is a waiting period for a CQE. For a felony, it's 1 year from final discharge, and for misdemeanor convictions, it's 6 months. And again, final discharge is satisfaction of any sanction that was issued against the individual as part of their conviction or their sentencing. The application for a CQE, I wouldn't say it's difficult, but it is multi-step. So the first step is to apply through the Ohio Department of Rehabilitation and Corrections. And again, I provided the website to you. That link opens up to the actual application website. An individual has to go in, create an account, and then you complete the application on that website. It gets submitted to the Department of Rehabilitation and Corrections. They initially do a review for completeness. Is the application complete? Is all the information in it? And is the criminal history that's provided accurate and complete? DRC will approve it. They have some system where they do actually transfer approved CQE petitions to the Common Pleas Court in the county where the individual lives. But for whatever reason, the petitioner themselves actually has to take, again, that affirmative step of filing the petition with the Court of Common Pleas in the county where the applicant resides. So I'm stressing this because with criminal convictions, you file the record sealing in the court where the conviction occurred. For CQEs, it gets filed in the Court of Common Pleas in the county where the person resides. So it doesn't matter where the criminal convictions that are included in the criminal history arose, the CQE application gets filed in the county court. Once the CQE is filed, it gets randomly in the court, it gets randomly assigned to a judge. They order a probation report, just like they do for criminal record sealing. The prosecutor is notified. I didn't mention that with criminal records, but they're also the prosecutor is also notified when a petition to seal a conviction record has been filed, and they have an opportunity to object. But then again, once the court has all the information that they need to determine or make a decision or a ruling on the CQE, they go ahead and do that. And what they're looking for is whether the individual, sorry, I skipped the slide in my own notes. So the petition itself asks several questions. There's identifying information, obviously, but then it asks the petitioner to explain their reason and need for a CQE. They must include their complete employment history, their complete criminal history, and they have to provide verifiable references, both family and non-family. And again, a detailed reason why the CQE should be granted. The court reviews that petition, and what they're looking at is whether or not the individual has shown, and again, this is legal language, whether they've shown by a preponderance of the evidence. Natalie, you could advance to the next slide. What the court is looking at is whether they've shown by a preponderance of the evidence that the petition will materially assist the person in obtaining employment or occupational licensing, that they have a substantial need for relief in order to live a law-abiding life, and that by granting the petition, the individual does not pose an unreasonable risk to safety of public or an individual. These are the factors that the statute lays out the court is to consider. Again, in our experience, most of these CQEs go through the court pretty smoothly. And in a lot of cases, the judge will not even schedule a hearing and will approve it without, any, without having met or had a hearing to meet the petitioner. When the CQE is granted, again, it removes any automatic bar to occupational licensing and certification. So again, that person can go to the licensing body and say, I know that the statute says I can't do this work, but I have this CQE. Please consider me as an individual for licensing. And again, it can be used for general employment provided to an employer. The decision makers who are making decisions about employment or licensing, again, then are allowed to sort of say, well, we know there's that statutory bar, but we're going to look at you as an individual. And then if the person is convicted again of some new offense, the CQE is automatically or presumptively revoked, I suppose, until there's a resolution of, whatever that new offense is. Okay, so that's CQEs in a nutshell. I want to focus real fast just on how you as service providers can help us in our work. The most important thing you can do is assist people with accessing and collecting their criminal records. And then the second most important thing you can do is refer them to legal aid so we can help with the eligibility analysis and get them scheduled for our expungement clinics, or get them assigned to an attorney to assist with the CQE process. There are a number of different ways to find criminal records. Public records are those court dockets. Most court dockets, I would say, I think all court dockets now are primarily online and easily accessible. The downside of searching court dockets is it's time consuming. The individual kind of has to have a good idea of where their convictions are, and to point you in the right direction to find those. Another option in Ohio is an individual can request their own criminal record background check through certain BMVs that run what are called a web check. And they can do that on their own. That gets run through the Ohio Bureau of Criminal Investigation. You can request that it include an FBI check as well. I looked yesterday for current cost for doing the BCI web check, and I couldn't find any current information. At least as of a year or so ago, it was about $50 to do both the BCI and the FBI check, but that does typically give sort of a complete criminal history. And then the last option is anybody can go to a private background check company and pay to have a background check done on themselves. Those are definitely more costly. What we typically need for individuals who are coming to us is a complete history and then a knowledge or understanding about what was the disposition of each of their cases. Was it a conviction? Was it a dismissal? And that's where gathering those records really become important. And then I thought one last thing is I would just give you sort of a snapshot of what a background check report might look like. Here, it identifies what was searched, the National Criminal Database. This is redacted, but you would see a name and social security number of the individual whose background was searched. There's usually information about who was requesting the background check, and here it says Script Fleet. I believe, if I recall, this was a trucker, so it was a trucking company that was seeking the background check. But the background checks will include the court where the criminal record is from, again, the offender information, the identifying information, name, date, birth, etc. And then it should detail what was the offense, the fines, the case number, the outcome, so in that first example, the individual was found guilty of falsification. And then you can see the next box that starts a second criminal record, also with the Lorain County Municipal Court, same thing, offender information, and then it goes into detail about what the offense actually was. So again, I mentioned legal aid's process, but it is really helpful when folks come to us for our clinic and to go through record sealing and CQEs, that they already know what where all their convictions are and have those records and know what those dispositions are. All right, I think I covered everything I wanted to cover. I want to make sure I have time for questions.
Julie, thank you so much. So again, feel free to post your questions in the chat, or if easier for you, you can simply unmute and jump in. Since we can't see everybody's Zoom box, feel free to just speak up if you're trying to get a question in that way. A couple that have already been asked. Julie, can a DUI be sealed?
No. It's, so DUIs, they're actually part of some of those traffic offenses, the way that they're detailed in our statute, and generally like a speeding ticket is not expungible. So most traffic offenses are not expungible, and DUIs in particular are carved out as a conviction that is not sealable under the record, under, the statute.
And just to give you one other example of that, am I correct that that is also true for domestic violence convictions? Those are carved out as something that cannot be sealed.
Yeah, so, right, because domestic violence convictions are, they sort of fall into that bucket of offenses of violence. But I would have to check on it. I want to say that I think with some of the updates to the statutes that have occurred over the years, I want to say it has to be a domestic violence offense that is a misdemeanor, a first-degree misdemeanor or above. So if it's a second, third, fourth-degree misdemeanor, or I'm not aware of any domestic violence convictions that are considered minor misdemeanors, but I believe it has to be a first-degree misdemeanor or above. I actually have a really great handy sort of fact sheet that does a great analysis of how, these different pathways and all the laws that the Ohio Justice and Policy Center, based in Cincinnati, put out recently with the most recent statutory changes. And I will send that to Natalie so that she can send that out with the PowerPoint presentation and the evaluations.
Sounds great. There were some questions early on about juvenile expungement as distinct from record sealing. And I did put in the chat a link to the page on Legal Aid's website that talks a little bit about juvenile expungements, but do you have anything more you'd like to add just to make the distinction between an expungement for a juvenile record versus the sealing of the adult criminal records?
Sure. I mean, I'll just say, first I'll say Legal Aid does handle juvenile record sealing, and that does not go through our clinic. Those come up to the unit and are assigned to attorneys in the unit to work through and assist with the juvenile record sealing. It is a different process. And actually it's more widely available. The only offenses that can't be sealed at the juvenile level are murder, rape, and arson. But any other delinquency is eligible to be sealed. Most courts in our experience have a form or a process. There are certain eligibility requirements depending on the age of the applicant. Are they under 18 or over 18? Have they, been released from the jurisdiction of the court? I'd have to review the statute again, but typically most people have to go through sealing of the juvenile record first and then expungement, but you can actually apply, you can submit one request at the same time and the court will seal it, then expunge it. There is a provision that I believe most offenses are supposed to automatically be expunged once the juvenile reaches a certain age, and I want to say it's 21 or 23. But in my experience, that does not necessarily happen automatically. And there are circumstances where someone, is in their 30s and some juvenile record is still popping up. And in those cases, it's just a matter of petitioning the court and doing that. But certainly, I would encourage you to refer folks to Legal Aid for that juvenile record sealing.
There was also a question earlier about if there were any differences in the rules for participants in drug court, and I would add, is that true for any specialized docket, whether that creates different eligibility for record sealing by participation in those specialized dockets like drug court?
Yeah, so I'm not certain for sure. I do know, I don't know specifically for drug court, but I do know, when individuals participate in diversion programs or those sort of alternative resolutions, there is often a provision that once that is completed, the record will automatically be sealed. I would have to look into whether that occurs in the drug courts in the region. So I don't have a definitive answer, but a lot of times in those alternative programs, they will seal it at the conclusion of that participation as a matter of course. But if it's not, there's no reason they can't otherwise participate in the record sealing process.
Thank you. So a couple of other specific questions. If a policeman pulls a person over and looks that person up before getting out of their police car to go over and speak to the individual, is that police officer able to see the individual's full record, even inclusive of past records that have already been sealed?
So I don't know, because I don't know what pops up when a police officer checks something. Again, I would have to look at the specific language of the statute again, but I do know it's very clear under what circumstances law enforcement are allowed to see sealed records. And I know for a fact, you know, like if an individual has been charged again, law enforcement is going to be able to see that. I don't know for certain though whether that information, I would presume sealed records do not pop up on just like a traffic stop like that, running a driver's license or a license plate, but I don't know for sure.
Thank you. Okay, great questions coming in. How about, are there any limitations on CQEs based on the offense or the degree of the felony, et cetera? I think if I understand this question correctly, it's can anybody apply for a CQE, or are there limits based on the offense?
So there are no limitations based on the type or level of the offense. It will be more challenging for someone who has a first or second or even third degree felony, depending on what the offense is. But I have actually represented an individual successfully to get a CQE on a conviction for attempted murder. So there is, or maybe it was aggravated murder, but it was definitely a first or second degree felony offense in that. So I will say with both record sealing and CQEs, once they come completely late and we do the analysis, with the CQE, we do an eligibility analysis, we help draft the CQE, we file it with DRC. Once it's approved with DRC, we give the individual the petition and advise them and provide them with information on how to go through the court process on their own. For most individuals, that is a very simple process. If someone were to come to legal aid with a higher level offense like that, we would likely provide representation through the whole process. So we try to identify those cases at the start where we think it's not going to go smoothly, or there's going to be some objection from the prosecutor, something along those lines, and we will provide extended representation to make sure that they're able to get through that process. And for both the record sealing and CQEs, when we send them on their own to go through the court process, they are told to come back to us if they have any problems. So we routinely have clients who come back and say, I got denied without a hearing. What do I do? The prosecutor objected. What do I do? I got notice that they objected and their reasons why. What do I do, et cetera? And we do intervene in those circumstances. We've certainly filed a number of appellate cases and have had good results there. But for higher level offenses, we do pay attention to those and try to anticipate where the bumps in the road are going to be through the process.
We are just at 10 o'clock, and that's when you all are supposed to get a break, but we have two final questions and then we will take our break. Yeah. Can fifth degree felonies be expunged? And I don't know if the person really means can they be expunged, or if they're really meaning can they be sealed, and then right. We use a CQE instead. So
again, we're talking about record sealing, not expunged. Expungements really don't apply in Ohio. Yes, fifth degree felonies can be expunged so long as the person meets the definition of eligible offender. We most often see fifth degree felonies, individuals meeting that first pathway of eligible offender. And there you can have fourth and fifth degree felonies and an unlimited number of misdemeanors and still meet that definition of eligible offender, so long as they are not violent offenses or sex offenses. If they are violent or sex offenses, then you have to move on to analyzing the second pathway. And there it depends more on the number of convictions and sort of the mix of the felonies and misdemeanors. But the only bar to felonies are first and second degree felonies. Those convictions cannot be sealed.
And then once somebody graduates from an alternative court, how long does it take for the record to be sealed? Or overall, how long does it take for a record to be sealed once an application is made?
So I would say, it's hard to give you a definite number, but I would say most of the courts in our region are pretty good about moving record sealings along. In my experience, a lot, particularly the municipal courts, once the application is filed, I would say a hearing is usually scheduled within 30 days. And then once that hearing is held, it's, I would say probably no more than a couple of weeks before the judge issues a decision. I would say for record sealing, probably no more than maybe 3 months total, but it is dependent on the court and their docket and how quickly they move. CQEs tend to take a little bit longer because those are in the Court of Common Pleas. It's larger dockets. CQEs aren't necessarily up there in terms of priority when they're addressing criminal cases and things like that. And so it takes a little longer, but I would say the long end for a CQE is around 6 months.
Great. Thank you so much, Julie, for all of that
Thank you.
information, and to all of our participants for your great questions and staying engaged this morning. We are going to take a break until 10:15.